David Kaplan. Welcome to the Inquiring Mind Podcast.
Thank you. Good to be with you.
Yeah, thank you for coming on the podcast. I want to first say that I really enjoyed this book. Uh, as an aspiring law student myself, I found it very thought provoking and engaging. Really well written. So
Where
obviously,
what year of law school are you in now?
well, I'm not in law school. I'm an aspiring law.
All right.
I'm
Well,
trying to go to law school.
it's not
Uh,
too late to turn back.
uh, we'll get to that in a second. I was wondering. Well, actually, that's a pretty good start. I know that you went into a career as a journalist, but you have a law degree. I think you went to NYU Law School, correct?
Correct. I have a law degree and I practiced for a few years before I sort of went back to journalism. So I saw the dark side and but emerged unscathed.
I'm always curious why. Um, I've said this before, but every time I tell people I'm going to law school, especially two lawyers, they always tell me not to do it, which is very odd to me. Very
It's
odd to
just a
me.
way to keep it's just a way to reduce competition and means the lawyers make more money. That's why they're telling you that. No, yeah, I there's always a certain amount of kvetching, perhaps in any line of work, whether it's a senators or dentists, maybe not Nobel laureates, but I think that the legal profession, and numerous studies have shown this, not just anecdotes, the legal profession, a lot of unhappy people in it. Much of what goes on in law is boring. You wouldn't know that watching TV shows, dramas, but a lot of litigation, most litigation is tedious. A lot of corporate work is drudgery. So when you combine that with the economic model that lawyers mostly still use, which is billing by the hour, it can make for a lot of unhappy folks. Uh, if you're a brilliant lawyer, um, other than by charging more per hour, you get paid in the same way as a mediocre lawyer. You don't get a premium for getting the work done faster. You get paid by the hour. And it's kind of a dumb model. And there are some efforts to reform it. There's experimentation with other models, but it's pretty much at least in the corporate world, in corporate law, it's run by the billable hour. And when young lawyers, like you, when you got out of law school, go off to work at a big law firm, it'll be great to earn $200,000 a year your first year, probably even more than you're making on a hosting a podcast. But you'll have to work 2,000 hours a year, and that doesn't include lunchtime and going to the bathroom and your commute. So I think those realities conspire to make a lot of lawyers unhappy. A lot of hours, a lot of drudgery. Um,
And
and, in
was there?
journalism, though I haven't gotten rich, um, it's not that way. A lot more
Mhm.
creativity. Um, I work hard, and writing books is really hard. Hardest thing I've ever done. Takes a lot of time, but it's self-directed.
Yeah, yeah. Um, I actually spoke to a historian two episodes ago, named Benjamin Hett, who teaches at Hunter College. And he was also a lawyer for 4 years in Canada and then got his master's and PhD, I think, in history. And I'm always curious as to, is there a moment that people realize that, you know what, I don't want to do this anymore? Is it the fact that you have no personal life? Uh, because the 80 hours to 100 hours, whatever I hear a week, it sounds insane.
It's not just the hours. I mean, neurosurgeons work really hard. Um, my dad was a surgeon. My older brother's a surgeon. I don't think I don't think my dad was unhappy being a surgeon his whole professional career. I don't think my older brother is. I think there's more unhappiness among lawyers, and surveys bear that out. I don't think they do it. I don't think they're as unhappy as dentists, and that's another, that's a whole nother line, which we could talk about, and I don't know anything about. That's what we journalists do. We talk about things we don't know anything about. But I mean, dentists are, I think, are known as being an unhappy group in part because think of what it's like to have your hands and face in people's mouths all day. But also, a lot of dentists, at least anecdotally, we hear probably want to go to medical school, and they settled for seconds. But I think you can work hard. And when I was writing The Most Dangerous Branch, I had lots and lots and lots of 100-hour weeks. It's the way you write 100,000 words. Things AI, there aren't AI programs yet to write your books for you, nor are research assistants quite that good. So I'm happy to work hard, but so I don't think that's the core of the matter. I think it's the model requires you to work hard, no matter how efficient or smart you might be. Plus, most of the work, most of the time, is drudge work. And I practiced for a few years on Wall Street, went back to journalism, which I had done a lot of in summers, wrote for a great college daily. So certainly had the bug, but I meet lawyers all the time and law students when I go back to speak at NYU, for example. And you get a lot of, gee, why'd you do that? How do I do that? How do I get off the beaten track? Anyway,
If people are
you'll find
planning their
time at law school. Just don't tell me you weren't warned. And my law degree certainly helped me throughout my career. I don't write about law exclusively. My first book, a bestseller off the bat, was about Silicon Valley, and I got Silicon Valley religion sort of serendipitously. I did a fellowship, a year-long fellowship at Stanford out in California in 1994 and 1995. It was the latest tech boom at that time. Netscape was going public. Yahoo was getting started. It was sort of the right place to get religion. And I've written about baseball on and off for my whole career. Haven't found a book to do about it, but I would not have gotten my first journalism job, nor would I have been hired quickly thereafter at Newsweek, but for my law degree. And I also think I wrote pretty well and knew how to do journalism, I think, early on, mostly from the college daily. But going to law school certainly helped my writing and clarity and precision of thinking. So I don't think you need those things, but law school certainly helped in terms of skills, and it got me hired,
right.
which I would not have been otherwise.
Mm-hmm. Well, I think that's a pretty good segue into asking my next question, which is, as I mentioned, at the intro of this podcast, you have this book, the Most Dangerous Branch, that I enjoyed. When did you first decide to write this book?
Well, I've written about the court on and off for years, and for my first 10 years at Newsweek, I was in charge of our Supreme Court coverage. We do articles weekly, and the New York Times covers it day in and day out. We would cover the big cases, the major rulings on abortion. We would cover nominations to the court, and I was the go-to person on that. We had reporters in Washington who could do a lot of the legwork. I would go down to Washington at times, but otherwise would be writing about it in New York based on legwork that was being done in DC. So, and the theme of The Most Dangerous Branch, that the court is simply too involved in American life, too interventionist, not because of a liberal reason, not because of a conservative reason. I mean, I'm a card-carrying liberal, so it's not partisan in that sense. It's an institutional argument that the court is just too involved in any number of areas, and we can talk about them. And that's the core of the book, as well as a look inside the court, how the place works, what are the justices like inside an institution that that isn't written about much and that people don't normally get inside of. But I think the moment crystallized to write a book when Justice Antonin Scalia died in early 2016, and you heard, and this is when the presidential campaign of 2016, Hillary and Donald is just starting to ramp up. You heard from both sides that the next justice, depending on who wins the presidency, the next justice could well determine American social policy for the next generation because of a swing vote. And I mean, you can be liberal, you can be conservative, you can be communist, you can be whatever. Do you really want a country, a democracy, which is run by unelected, unaccountable justices, where one vote of the court on any number of key social issues and economic issues, Obamacare, abortion, gun rights, affirmative action, gay marriage, you name it, is decided by and will be for 25 years by a single individual. That strikes me as nuts. So I think it was at that moment that I decided, and it was a good time to be doing it as the presidential campaign was heating up, and the book would come out in the middle of the presidency of whichever candidate won. This would be a good time to write that book. Fortunately, there were publishers interested, and I wound up writing it for a wonderful editor at Penguin Random House. So it worked out fine. Yeah. Publishing plan, you commit a long, if you're lucky, and I was, you get a good advance, which means you're going to get paid for your efforts. They don't know if the book's going to sell or not. So it's a great system for authors, but you got to do all the work. You want the book to be a success, and who knows what's going to come of the book. Now, my book wound up being published in 2018, just as the Kavanaugh hearings were going on. So it was perfect timing. It was great. The Supreme Court was in the news. So it was serendipitous. But I wrote a book that came out in 2001 called The Accidental President, which was about the presidential election of 2000, way back when. George Bush and Al Gore, back when presidential candidates were just normal people with normal partisan differences. And, and the battle over Florida way back when was titanic. And I wrote that book, in 6 months. There were tons of books coming out about the presidential election. All were bestsellers. I had all kinds of scoops about what went on actually at the Supreme Court and inside the campaigns. And the book was all set up structurally to be a big hit. Unfortunately, it was published on September 10th. So, you publish the day before 9/11, the book was going gangbusters, front page of cover story in Newsweek, Today Show, Charlie Rose, if that name means anything anymore, all over cable news. I mean, the book would have done spectacularly, and it sold a phenomenal amount over the course of a day or two. Then 9/11 intervened. Now, it could have been worse, I guess. Could have been published on 9/12. But so that book was an extremely unimportant casualty of 9/11. Book publishing is serendipitous.
Right.
Don't write a book either.
I'll just keep doing this.
Go to medical school.
Oh, I think it's too late for me. But one of the things that I've noticed, again, you point to this moment that pretty much changed everything, is when Scalia passed away, and there was this race to pick our next nominee.
Well, there wasn't a race. Obama nominated Merrick Garland,
right.
Judge Merrick Garland, now the Attorney General, and the Senate, the Republican Senate, did everything other than racing to deal with his nomination. They wouldn't even give him a hearing. there was actually abject delay by Republicans to see if just maybe Donald Trump would win the presidency in November. And lo and behold, he did. And that's why you got Neil Gorsuch on the court. So,
Yeah. But one of the interesting things is when you look at nomination hearings from the past. So if you look at Scalia's, for example, or maybe even Ruth Bader Ginsburg's, the one thing that strikes you, and I'm a pretty young guy, um, is, is the type of questions that are asked and the way people behave. It's not a circus. It's not, people trying to have gotcha moments. It's just, they're cracking jokes, they're asking serious questions. Most people are going to vote for this guy or woman regardless of their opinions. So when did this all change? When did it become so partisan?
well, I'm not sure I would agree that senators aren't looking for gotcha moments. There are senators who are well versed in matters of the Supreme Court, versed in matters of constitutional law and history, but not most of them. They're as good as the staffers who put together materials for them to read. And most senators are looking for gotcha moments, so that the folks back home can see you saying something. Now, when John Paul Stevens, Gerald Ford's sole nominee in the 1970s, was nominated to the court, he was confirmed 17 days later. The whole thing took 17 days, like an old print shop while you wait. So once upon a time, it was different, and hearings weren't televised back then. So you're quite right. At many times, not in the modern era, these things were pretty routine. But Richard Nixon's series of nominations were extremely controversial. Most senators, of course, also, they don't understand what the Supreme Court in theory does. They think it's just another political branch of government. Super legislators voting their political partisan wishes on abortion, or whatever issue. And I don't, cynic that I might be, I don't think that's what most justices do most of the time. They certainly don't aspire to do that. So I think most senators don't get it. Not that they get lots of other topics. Certain senators are quite good at this, are quite knowledgeable. And Barack Obama once taught constitutional law. So both as a senator and as president, he was facile in such matters. Going to the heart of your question, when did this become politicized? It became politicized, hyper politicized, once presidents started nominating people to the court, chiefly because they thought the nominee would vote the correct, quote unquote, way, be it on abortion or some other issue. And that probably began most dramatically with Robert Bork. Ronald Reagan nominated Judge Bork to the Senate, ultimately rejected him. And Bork was a brilliant academic, writer, and extremely competent conservative judge. But those qualifications were beside the point. They were a necessary condition of the nomination, but he was picked because of the belief that he would vote the right way. And he was very clear and emphatic on what he thought of Roe v. Wade, the abortion ruling that constitutionalized abortion. Most nominees to the court, and certainly thereafter, hem and haw. They don't commit to any to a view on any case other than perhaps Brown against the Board of Education, the iconic 1954 ruling, which said that the segregation of public schools was unconstitutional under the 14th Amendment. So, those who say that it was outrageous that Bork was defeated, given that he was qualified, of course, are disingenuous, or just stupid, because he wasn't nominated for his qualifications. He was nominated because of the belief by Reagan of how how Bork would vote on key cases. And presidents are allowed to do that, but that process really got that agenda really got ramped up with Bork. Now, not always. David Souter, chosen by the first George Bush, was chosen in part because they wanted to get somebody quickly nominated, and the White House Chief of Staff, Governor John Sununu, former governor of New Hampshire, vouched for David Souter. They wound up being wrong. David Souter turned out to be, relatively speaking, quite liberal. Clarence Thomas was nominated by the first Bush to replace Thurgood Marshall. They had to pick an African-American nominee, and Thomas was very young. He's 42 at the time. Within the decade, he's going to become the longest, assuming he stays on the court and is healthy. Clarence Thomas will be the longest serving justice in the history of the Republic. They thought they were getting, someone who would vote the right way. Ginsburg and Breyer were nominated by Clinton with the view that they would be left of center. Now, not perhaps as right of center as Bork. Breyer and Ginsburg were beyond question competent. They were well liked in Washington. Breyer had worked on Capitol Hill, and they were nominated and they were approved uneventfully. When John Roberts was nominated by Bush 43 to be Chief Justice, he pretty much sailed through because not a lot was known about his views. He was the best witness in modern times, as a nominee. Alito, who at the same time as Roberts, was more controversial. And Alito was pretty clearly and demonstrably, as a sitting judge, conservative, voting the correct way by conservative lights. And I think that's where you can mark the trend accelerating. And yet, Sotomayor and Elena Kagan, nominated by Obama, again, clearly liberal, but both appealing. Sotomayor was Hispanic, hard to vote against her. Kagan wasn't a sitting judge. She had been dean of Harvard Law School at the time she was Solicitor General. It's hard to point to anything that says, she was going to be, quote unquote, too liberal. So we've gone through all of these, and there are ups and downs. Trump, you could argue, even more accelerated the trend by picking 3 nominees who were going to give the right and the anti-abortion folks about their best hope since Robert Bork. Now, Gorsuch was controversial in part because he was taking the quote unquote Garland seat. Kavanaugh was controversial for other reasons. Barrett was controversial because she was taking RBG seat. So it's not necessarily a straight line, but I think a lot of factors have conspired to make court nominations highly politicized. And part of the problem, and this, undergirds my book, is the courts only become more important because we have a dysfunctional Congress. You don't get anything done. There are a variety of reasons for that. And there's an interplay between Congress's problems and the court's arrogance. But because the Supreme Court decides virtually every important issue in the country, other than military affairs, then who sits on it becomes all the more important. And one of the reasons Congress is impotent, I mean, part of the reason is because it has a lot of chuckleheads in it. But another reason that Congress is impotent is because they recognize that the key issues are ultimately going to be resolved by the Supreme Court anyway. Why should we stick our necks out? If you go back to Bush v. Gore, which decided the 2000 presidential election, and which I write in the book is the worst decision of the court, probably since Dred Scott in 1857. The ruling on slavery that was pivotal in leading to the beginning of the Civil War 4 years later. In Bush v. Gore, where the signature case where the Supreme Court should have stayed out, where the justices should have said, hey, go across the street to the Capitol. The Constitution itself and federal statute explicitly describe what happens in the case of a disputed presidential election. Congress decides, not the justices. The Supreme Court nonetheless interjected itself. The Supreme Court decides what cases it's going to hear. Nobody forces the Supreme Court to hear cases. It's up to them. And when the Supreme Court did that, you would have expected, but not really, you would have hoped that Congress would have filed a brief before the Supreme Court, an amicus brief, friend of the court brief, saying, hey, wait a second, guys, that's our job. Stay away. They didn't file a brief at all. No senator went up to the microphone, inside or outside the Capitol, and say, hey, wait a second, this is our job. Now, I interviewed a bunch of the senators. I quoted Joe Lieberman, remember, who was the vice presidential candidate of Al Gore back in 2000. And Lieberman's a smart guy, and explained in part, there was a press of time, but in part, why should we step in when the court's going to do so? And if you want to know if you want to recognize the irony or the hypocrisy of justices, you take someone like Antonin Scalia, an affable, funny, great writer, who made a career not only of being affable and funny, but of criticizing the court for intervening where it shouldn't, like on abortion. It's not our jobs. Who do we think we are getting involved? And yet, in the aftermath of Bush v. Gore, Scalia would go speak at law schools. He spoke in TV interviews on Charlie Rose, saying, hey guys, get over it. If not us, who was going to resolve the presidential election? We were the laughingstock of the world. And, I pulled out my Constitution. I read it front to back just to make sure I hadn't missed it. And I couldn't find any laughingstock clause in the Constitution. I couldn't find anything that said in the case of when the United States is a laughingstock, the Supreme Court has to step in and fix things. So, for Antonin Scalia, who introduced the notion of textualism into constitutional interpretation, look at the words. And it's now so embedded in American law that conservatives and liberals alike invoke it. The great champion of textualism, obviously, in saying, hey, we were the laughingstock, who but us, was a complete hypocrite. Now, he didn't say that in a ruling, but he said it extrajudicially, and that's where from his view came. I asked him about that subsequently. I met with him. And, essentially he smiled and just gave me, a flick of the chin. He didn't take the question seriously, but I think he did. There is no answer. One of the reasons that the Supreme Court gets involved, it's the answer to an old joke we can't tell in the family hour. The Supreme Court gets involved because it can. But, and various justices have said this throughout history, the most important thing the Supreme Court can do is not decide. Justice Louis Brandeis said it most famously. It's really hard for any decision maker to say, you know what? No. Go back to some other governmental body, for example, or organization in the private sector to make a decision. It's really hard to do that. And the Supreme Court has become really bad at it. And what are the consequences of that? It reduces the Supreme Court's institutional capital to rule in areas where it ought to get involved, like Brown against the Board of Education, where the court's imprimatur is necessary, and to sell it to the country, because the court can't enforce its rulings. All it has is the power of persuasion. If the Supreme Court is ruling on this and that social issue, its capital is reduced. And while the court is highly respected relative to other branches of government, and certainly to we journalists, us journalists, its numbers are down, and it's been pretty much a steady decline since Bush v. Gore in 2000. So that's one harmful effect of the court being so self-aggrandizing. What else does it do? As we talked about, it helps make Congress more impotent. And it raises the stakes of confirmation hearings. When each nomination is so freighted because so much rides on it, and with nominees so young, the day's coming where we're going to start putting justices on the Supreme Court right after their bar mitzvah or bat mitzvah. No, I jest. But, you could see John Roberts nominated at age 50. Neil Gorsuch nominated at 49. They could be, I think Barrett was 48. They could be on the court 35 or 40 years. Thomas, as we talked about, could easily be on the court for 40 years. He could be on the court longer. So if the Supreme Court doesn't like the politicization of nominations, and Stephen Breyer is coming out with a book in the fall of 2021 criticizing the politicization. One of the reasons the court is so politicized is because the court gets involved so often. And we don't need to relitigate Brett Kavanaugh and Christine Blasey Ford here. And that was certainly an important allegation that she made. But one of the reasons it became so freighted is because the Kavanaugh seat was so important. So I think the court, in the first instance, is complicit in the problem that all of them despise. I met with a majority of the justices. I spoke to a majority of the justices for my book. I can't tell you who they are because the condition of them talking to me on background was that I don't reveal who I talk to. But they all hate how freighted nominations have become and how politicized the court is. Well, look inward, people. You've helped create the problem.
Well, did you mention that to the justices? Well,
sure.
What did they say to that?
They did it.
It's
the other, when I would summarize for some of them, they say, give me the gist of your book, the elevator speech. The court's too self-aggrandizing. It's taken on too much power. It's too aggressive. And, I had one liberal justice say to me, I half agree with you. And I had one conservative say, I half agree with you. The problem is there was different halves. It's the rare justice who these days, who's modest, who who defers to other branches of government. Probably the justice who does it most is Breyer. Now, I mean, he's on the liberal wing of the court as we divide up those lines, but statistically, he defers to other branches, states and Congress, more than any other justice. They all but one in recent memory pay lip service to the idea of modesty. Anthony Kennedy, who resigned, in 2018 and opening up the Kavanaugh seat, Kennedy was not a hypocrite. He loudly and boldly believed in the power of the court. It's our job. He would talk about the majesty of the institution. This is what we were supposed to do. In all the hemming and hawing about Bush v. Gore that came out afterwards in interviews and books like mine, in stuff that they said in intervening years, Kennedy was the only one who didn't give any indication that he lost any sleep over intervening in the presidential election. And as I wrote in my book and others wrote, from the moment that Florida was becoming crazy town politically and judicially after Election Day in 2000, Kennedy was essentially keeping score. He was sending around emails to his colleagues. This case is coming up here. Go team. And man, it would be fun to decide the presidential election. I understand that. That's not your job, people. You ought to be resisting getting involved. And the great weight of belief in the country among constitutional scholars is that the Supreme Court will never, ever go near this. If you had to think of a more radioactive topic than deciding the classic political question, who won the presidential election, this is the one area they'll stay away from. And, those folks were wrong. Good for me. My book revolved around it. And, my book came out in 2018, and then the next year, The Most Dangerous Brains came out in 2018, and then I added an afterword the next year to account for what happened, the denouement with the Kavanaugh hearings. And when I've given a lot of talks on the book at law schools, at big gatherings, bookstores, at book fairs. I once had to try to compete with Alan Dershowitz at the Miami Book Fair. We had a room of 800 people, and as we walked off the stage after our hour and a half, he says, you got more airtime than I did. And I smiled, and I know Dershowitz, and said, yeah, that was the plan. I think it pissed him off. We've never spoken since, who knows? But I would try to make the argument, almost entirely unsuccessfully, that Bush v. Gore, at some level, Bush v. Gore and Roe v. Wade are the same case. Yes, I know. One's about abortion and one's about presidential politics. But you can't have it both ways. If you want the court to intervene in the presidential election, then it's fair game to intervene in abortion. And if you like Roe v. Wade, as we liberals do in its outcome, it's hard to object to them intervening in a presidential election. Now, that's overly simplified, but I'm just a journalist noodlehead. And, I'm simplifying. The root principle is the same. If you believe the court shouldn't get involved, except when it must, these are two classic instances where it shouldn't get involved. And of course, the problem is I would have lots of groups saying to me, but wait a second. I thought you were in favor of legalized abortion. And I would say, I am, which has nothing to do with the question of whether the Supreme Court ought to be the branch of government that establishes that right. They're not the same question. The ends don't justify the means. At least I don't think so. If you want abortion to be legal, battle it out and win in the legislatures. You know, the day is coming. You wait and see. Roe v. Wade will certainly be weakened by the current court. It may be outright overturned, next year. That will not be the end of the battle from conservatives. They will next argue that abortion should be constitutionally impermissible. The fetus is a person. Persons are entitled to constitutional rights under the 14th, are entitled to equal protection under the 14th Amendment. They will argue that not only is Roe v. Wade wrong, but not granting constitutional personhood to fetuses is wrong. I mean, I don't think that argument will be a winner, but don't be betting on my predictions. And, to me, that's supreme, no pun intended, hypocrisy. The right wing has been arguing for 50 years that abortion ought to be decided by legislatures, by the people. Of course, now that you've got 6 reliable conservative votes on the Supreme Court, the tune's changing. Go team. We want an activist Supreme Court. We didn't like activism when the commies were in control. We're of an aggressive judicial no different at all. And just so your listeners are clear, I don't want an impotent court. The Supreme Court is the most powerful court in the history of the world. And there's benefit to that. Brown against the Board of Education was an important, critically important ruling in American history. And in my view, and the view of just about everybody, it was correctly decided. I don't want the Supreme Court uninvolved in all matters, but I think they need to do a better job of picking and choosing. How do you pick and choose? I mean, the easiest way to explain this, and others have done this, including the court itself, way back when, is to say the Supreme Court sometimes has to enforce explicit, undeniable parts of the Constitution. Constitution says that you need to be 35 to be president. No, that doesn't mean 34. That really means 35. There are other instances of explicit text. Sometimes there are lower court disputes. The 12 federal appeals courts in the country issue different rulings, and you may need a national standard. Not necessarily, but you might. But the key area where the Supreme Court ought to get involved is when what we could call discrete and insular, or not original to me, discrete and insular minorities, that doesn't mean race, are unable to have their rights vindicated by the legislative process. The ins, majorities, aren't really good at recognizing the rights of the outs, minorities. And in certain instances of individual liberty, the minority has no choice but to turn to courts, which are insulated from political pressure. Federal judges, Supreme Court justices are appointed for life. So First Amendment rights, the ability to speak unpopular and publish unpopular views, that's never going to be protected by the majority. By definition, the rights of criminal defendants, murderers, alleged murderers, that's never going to be protected by the majority. You need a court to protect their rights, the rights of racial minorities. And we have a 13th, 14th, and 15th Amendment, the Civil War amendments. the rights of minorities are not going to be protected by the majority. I mean, that's a truism, but you look at the history of the country, slavery, Jim Crow, etc. It's a pretty rich history of minority rights not being respected. Who but the Supreme Court? What branch of government but the Supreme Court can step in and protect those rights, which is why, and I argue this in the book, almost as bad as Bush v. Gore was the decision in 2018 by the court to not get involved in gerrymandering. Partisan gerrymandering, drawing lines to benefit the party in power, often Republicans, often Democrats. The Supreme Court said, you know what, that's a political question. We can't get involved. Not for us to get involved. We can't get involved. It's too granular. And that's outrageous, in my view, because gerrymandering is the classic instances, I thought, where the court ought to step in, because the outs can't win in the legislature by definition. Structurally, they're set up to lose. So if you believe there's an equal protection problem, equal protection of the law, protecting the 14th Amendment, who but the court but to get involved? And, the court said in that instance, lo and behold, we have to respect the right of political majorities. And yet, why didn't they protect the right of political majorities, which enacted, the Civil Rights Act of 1964? Supreme Court gutted that in 2013 in the Shelby County ruling. Why not respect the decision of the DC legislators who enacted gun control rules? Supreme Court threw that out. These are all 5-4 rulings. Supreme Court threw that out in the Shelby County ruling in 2008. And the Supreme Court next year, 2021, 2022, will decide whether you have a right to carry a concealed weapon. The 2008 ruling, Heller, was only about the right to have a handgun in your home for protection. What about carry concealed weapons in public? Pretty ominous signs, given that the Supreme Court finally took the case, that they will constitutionalize that right. Excuse me, what about the rights of political majorities to enact those gun control laws? Now, of course, the Supreme Court conservatives will say, hey, the Second Amendment, but that's disingenuous. The Second Amendment argument in favor of the right of individuals, not militias, the right of individuals to own firearms is at best arguable. There's a very good argument to the contrary. If you go and wade through hundreds of pages of the 2008 ruling, Justice Scalia writing for the majority of 5 on the one hand, Justice Stevens writing for the minority of 4 on the other hand, the worst you could say is it's a close case. I think Stevens' opinion is much better, carries the day, has nothing to do with my partisan views on guns. It just doesn't. It's a better ruling. So if it's a close case in gun control, if it's a close case on voting rights, why not let legislators decide? Why not let people decide? Now, are there minority rights to be protected? Are gun owners the kind of individuals, a discrete and insular minority, that require the special vigilance of the Supreme Court? Come on. How many people own a gun in America? I don't know. Everybody but you and me? Well, me, I don't know about you. I'm exaggerating, but lots of gun owners. And are those who were hurt by the Voting Rights Act states that had histories of racial discrimination in voting? Were they somehow unable to enact other change? No. It's the hypocrisy involved, to me, is astonishing. The really hard case is same-sex marriage. And I had a lot of trouble with that in the book, and I did most of my hem and hawing in that chapter. My own political views support same-sex marriage, easy case. But I thought the case, and the Supreme Court ruled 5-4, constitutionalizing same-sex marriage. I have a lot of trouble with that ruling. Again, on the merits, not because I'm anti-gay, not because I'm anti-gay marriage. It's I'm not sure the Supreme Court correctly should have gotten involved or should have gotten involved then. Now, in retrospect, it's turned out fine. It has not been controversial in the way that Roe v. Wade was. I don't think it led to disrespect for the court, didn't lead to a loss of capital. And among the various judicial projects the conservatives on this Supreme Court want to undertake, getting rid of Roe v. Wade, dismantling the federal administrative state, that is the power of federal agencies, gun rights, affirmative action. I think those are the projects, call them political or judicial, of the conservatives. I don't think same-sex marriage is among them. I don't know that there are 5 votes to reconsider that issue, but see my prior comment that my predictions are usually wrong. I'm talking too long. I haven't allowed you haven't asked a question in a while. Sorry.
No, it's okay. It's okay. You have a lot more to say than I do, but I do want to ask. So you, for the most part, your book outlines, the many issues that the court has today. There are a lot of people that I've heard, some politicians, some, judicial advocates, are trying to make some reforms to the court. I've heard term limits. I've heard, maybe adding seats, taking away seats, whatever it might be. I think the simplest thing you could say is, well, the Congress should just do its job, and then everything would be fixed. Yeah, that's great, but that's never going to happen. You can't just tell Congress to do its job, because
do its job in terms of what?
Well, passing bills, doing their
well, sure, and they can't pass a bill to undo a constitutional ruling. When the Supreme Court rules on a constitutional issue, as opposed to a statutory issue, something based on legislation. When the Supreme Court rules on the Constitution, Congress can't step in and change it anyway. Supreme Court gets the last word on constitutional issues, supreme law of the land and all that.
Well, we spoke about you spoke about Roe v. Wade, right? It's
Congress cannot do anything about Roe v. Wade. Now, if the Supreme Court says Roe v. Wade is gone,
yeah,
and the matter goes back to legislatures, it most obviously goes back to state legislatures, and in theory, it could go to Congress. It's not 100% clear that Congress, it's not 100% clear what Congress can legislate on in terms of abortion. I mean, Congress can't pass laws on anything. There's certain areas that are matters for states to handle. Mm-hmm. We do have a federal state, system, and not everything is fair game for Congress. But anyway, you're asking a question. Term limits, other stuff, yeah. You say you want to know what their prospects are?
I don't think it's going to happen. That's just my personal opinion. There are not going to be term limits. I don't think they're going to add any seats to the Supreme Court. This is all, election year talk.
I agree with you. You can click your heels 3 times and you're not going to be back in Kansas.
But in general, what do you see the future of the Supreme Court, and how do you resolve these issues? Or how do you begin to resolve these issues? Yeah.
You write books like this and hope people read it, and smart podcasters continue to give you a voice even a few years after the book is out. But, listen, it's a hard argument. My spouse, who I give, my manuscripts to for editing, she's a really tough editor. When I gave her this one, She says, why are you giving it to me? And I says, because I want your views on it. She says, but I don't like your position on Roe v. Wade. I don't want to make your argument better. So I have trouble convincing my own wife.
Yeah.
It's a hard argument. And the idea of a powerful Supreme Court is embedded in American society. We should distinguish, to your question, we should distinguish between term limits and adding seats to the Supreme Court. Call it, whether you call that court packing or enhancing the size of the Supreme Court. Labels are everything.
Right.
Term limits would require a constitutional amendment. Constitution says they serve for good behavior. That means life. There are various ideas of how to skirt that, but they're tricky, and we don't need to discuss them here and put your readers to sleep. Increasing the size of the Supreme Court is, by comparison, really easy. Thus, had nothing to do with the Constitution. Congress determines the size of the Supreme Court. All the Constitution says is there shall be a Supreme Court. Doesn't say how many there shall be, and there shall be a Chief Justice. And the Supreme Court, though not for 100 plus years, a Congress 7 or 8 times has changed the size of the Supreme Court. Not in 150 years. Right. And decreasing the size of the Supreme Court would be tricky other than by attrition, because getting rid of justices would run up against the idea of life tenure. But if you want to increase the size of the court, you need House and Senate to pass it and a presidential signature. It's really easy, except it's not. When FDR first initially broached this back in 1937, when a lot of New Deal legislation was being thrown out by the Supreme Court, the criticism among Democrats and Republicans to the idea of increasing the size of the court was robust and widespread, and didn't go anywhere. But that doesn't mean it might not go somewhere now. Now, it's not going anywhere in the current Congress, because even if you ignore the filibuster, lots of senators have said no. You can't get to 50. You might not get to 40. And Biden has said he opposes it. Now, there's a commission now studying reform to the Supreme Court. It's going to issue its findings or analysis sometime this year. Maybe they'll change the dynamic, but I doubt it. Mm-hmm. I argued in the paperback edition of my book, when I had the chance to write it afterward, that after hemming and hawing and sitting on the fence in the hardcover, that I'd come around to the position that Democrats should increase the size of the Supreme Court. I come around to the game theory proposition that you have to fight fire with fire, tit for tat. You don't bring, as I forgot which Republican pundit put it, you don't bring a spatula to a gunfight. And the Republicans have demonstrated time and again how really good they are at this. They blocked Garland's nomination, unprecedented in terms of norms. It's legal, it's allowed, and they rushed through a replacement to RBG. Her body hadn't cooled, and they were on the Amy Coney Barrett train.
Yeah.
Another violation of norms. Would the Democrats have done that in a different situation? My guess is they would have liked to, but they're bad at it. And I don't think they would have been able to stonewall in 2016. Democrats are really bad at being bad. It's, on the one hand, it's a good thing. On the one hand, it's a bad thing. And a lot of the hemming and hawing about Democrats now about packing the court is understandable and noble and really stupid. Because I think the only way to fight Republicans on this is to fight fire with fire. Will it be bad for the court? Yeah. Steve Breyer is correct it will further politicize the court. It will make the court look like just another political branch of government where its members are voting their personal political partisan predilections, which the public already thinks now is largely the case. Really bad for the court. I agree. And when the next Republican comes into office, Tom Cotton, Nikki Haley, God forbid, Donald Trump or his son, if they have control of Congress, they'll put some more members on the court to undo what the Democrats did with their additions to the court. And eventually the court gets bigger and bigger, and they'll have to put Southwest Airlines seats, up on the bench to accommodate them all. And it becomes absurd. My argument, such as it is in the book, was that eventually both sides come to disarm. Both sides understand this is untenable. You've got to bilaterally disarm and return to the days of what you referred to earlier, when nominations were pretty uncontroversial. John Paul Stevens, nominated by Gerald Ford, turned out to be extremely liberal in the court. He was just regarded as a really good federal judge in the country. Gerald Ford's Attorney General, Ed Levy, was tasked with finding a good judge. They didn't want, a crazy liberal, but he was just a really good judge. He wasn't picked because of his politics. And there are a lot of justices over the course of its history, even in the 20th century. You don't have to go back to names you've never heard of in the 19th century, where good candidates were chosen based on credentials. They weren't all judges. Some were U.S. senators. Others were attorneys general or people in public life. You hope for a return to those days where you're not just picking nominees who you think will vote the correct way. How long would that happen? Well, possibly never. Would it be 5 years? No. The argument in my book is that maybe it would be 15 or 50. But I don't think you break the cycle. I don't think you get the Republicans to disarm unless you bring a gun to the gunfight. Will any of that ever happen? No. Because I don't think Democrats, they have 50 seats in the Senate now. They could do it tomorrow because the House would vote in favor of it, I think. And I don't know that they'd get 40 votes. They certainly wouldn't get 45.
Yeah.
I don't think they'd get the 50. And if they maintain the filibuster, you wouldn't get the 60. They can't get DC statehood through. How do you argue against DC statehood on a principled basis? I think the only argument against DC statehood is it's going to vote Democratic. And as a Republican, and Republicans are never going to pick it. Well, that's fine. That's realpolitik. Realpolitik often governs, democracy. Just don't call it principle.
Yeah. Again, in the interest of time, I have a lot. I had a lot of.
I can answer a few more. I mean, you're paying me enough.
Yeah, no, but maybe to begin again, wrapping up, just in the interest of time. I ask two questions of all my guests at the end of every podcast. One, if you have any, what gives you hope for the future? And that could be as general or as specific as you want. And then the second question is, what are 5 books on any topic, fiction, nonfiction, that you would recommend to anyone on any topic? It could be more than 5, by the way. Sorry.
Yeah, I'm just thinking of getting to 5. I mean, I like to think I'm not a pessimist, which is optimistic in itself. I'm not sure that I'm much of an optimist. I don't like where the country is, the level of disconnect between both political sides. The idiotic debates we have over the science of COVID, the fact that you can't convince a substantial number of Americans to act in their self-interest and get vaccinated. Forget trying to help their neighbor, but their own self-interest in getting vaccinated, despite the microchips that Bill Gates might put in their bloodstream, and you expect large issues like climate change or immigration, or matters of race, matters of economics to get solved. I'm not particularly optimistic. I think if I were optimistic, I think it's when I listen to my students. I've been teaching now 12 years at NYU and recently at CUNY as an adjunct. When I listen to them, when I hear my own kids speak about the future, that gives me some optimism. Now, I think when you're 20 and 25 and 30, you tend to be optimistic. You haven't seen as much nonsense go by. But I think that probably gives me hope. And the history of the country, the moral arc of justice, as King put it, and Obama has reminded us, and others, is positive. Things get better politically and socially over the long haul. So I think that's the reason over the long haul that gives me optimism. But over the short haul, the politics of reforms in Congress now, the 2024 presidential election, God forbid, the Supreme Court's arrogance, all the injuries on the Mets. I'm not sure. I'm not sure that I'm all that optimistic. What 5 books would I have people read? I think the books that stick with me they have to do with topic, for sure, but they're about writing. I think I really like to think that I really appreciate good writing. So, whether it's a book, whether it's Charlotte's Web from yesteryear, written by another Cornellian, whether it's a book about water in the American West, the Cadillac Desert, which probably nobody's, heard of, from the 1980s, whether it's some great books about the Civil War, which was the subject of my honors thesis in college. A book on the Civil War nobody much reads called Conflict and Transformation, written by a Brit, or The Impending Crisis, which won the Pulitzer Prize. These are all really well-written books. The Power Broker, staple of the background of anybody's Zoom during the pandemic. It's probably just over there. Almost anything written by Lincoln, his letters, his speeches. I'm trying to think of, the Power Broker is probably the best biography I've written. Anything by Shakespeare, although I'm probably not as good as, I don't have the patience that other people have to read it. That's probably off the top of my head when I'm trying to teach my students about journalism. That's the stuff I'll tell them, as well as some great pieces of journalism. I think for modern authors, anything written by John McPhee, another Pulitzer Prize winner, John McPhee, who's now probably well into his 80s, been a New Yorker writer since the 1960s, teaches writing, narrative nonfiction at Princeton. I think anything written by John McPhee is great. His first book, A Sense of Where You Are, short book, you can read it in 2 hours. Biography of Bill Bradley, former senator, former New York Knick. Bill Bradley in his senior year at Princeton. Just a brilliant piece of writing. But John McPhee wrote a book about oranges. I don't care about oranges. The Pine Barrens of New Jersey. I don't care about Pine Barrens. I don't care about New Jersey. But brilliant writing. And then, of course, he wrote a multi-part series on geology. He was named a fellow of the American Society of Geologists, and not even a geologist, called Assembling California. Brilliant. And then, of course, his best book called Coming into the Country, which was essentially a travelogue of Alaska. He went and spent a summer, wasn't more than one summer, in Alaska. And on our first trip to Alaska, we sort of used it as a guidebook. But and he's not a stuffy writer. He's a great observer. Anybody who can describe the architecture of Anchorage as having the best out of town anywhere, but the architecture itself as being early American dentist, is a writer I admire. But if you would give me some time to prep, maybe I'd give you some more recent examples. Unfortunately, and I think it is unfortunate, most of my consumption is of journalism rather than books, and almost all of my consumption is of nonfiction, other than what I read in politics. So I guess off the top of my head, I would mention that stuff. At least some of those examples might not be the same ones that others of your illustrious group of guests have mentioned.
Yeah.
And of course, my books aren't bad.
Yeah, definitely aren't. I was just about to mention The Most Dangerous Branch.
Oh, I should mention for baseball, The Boys of Summer is a great book. And there's a book written called 9 Innings, which is about baseball, a grand discussion of baseball, but told through the vessel, if you will, of a 9-inning game, written by the great Dan Okrent. That was pretty good.
What are your
Dan
thoughts
Okrent, huh?
Yeah, what are your thoughts on Moneyball? Did you like the book, or
I liked Moneyball, and Michael Lewis is a great
writer. Yeah.
Writer, who is able to take the complicated and the arcane and translate it. And yet, and I speak, I guess, parochially and maybe jealously, he and I were working on Silicon Valley books in 1998. We were both, as one reviewer put it, carpetbaggers. We weren't of the industry. We didn't live in Silicon Valley. And I wrote my book, The Silicon Boys. And some months later, he came out with a book called The New Thing.
Mm-hmm.
And sometimes they were reviewed together, and I did pretty well, but better, actually, ask my mother. But when we were writing about the same areas, venture capital, that was the overlap in our books. I guess I saw some of the tricks he employed, or the devices he employed. I think mine was better, something that reviewers noted, because I think his writing is so good. I mean, he's truly gifted. What he sometimes does is glides over the nuance with a turn of phrase or a simplification that ignores the reality. So when I'm reading something by Michael Lewis, I know something about, about baseball. And he wrote about Billy Beane. I had done a piece on Billy Beane for Newsweek. So maybe know something of that area. But mortgage-backed securities, if my life depended on it, I couldn't mention them in an intelligible, complete sentence. So when I read a book like that, or The Blind Side, they made it into the movie and about football. I watch football, but I don't understand it particularly. When I read something, I read it with a grain of salt, because I know that his facility with writing sometimes gets in the way of a level of complexity or nuance. That's not a particularly original observation. It's also it is the biggest gripe people will have with Malcolm Gladwell. I should have Malcolm Gladwell's book sales, but some will say that his popularizing of psychology and other areas of social science.
Oversimplification.
Exactly.
Yeah.
And my God, he writes well.
Yeah.
But, and I don't think my stuff is overly dense. I mean, I'm really proud of this last book, more so. I mean, I love my children equally, but I like this. I'm more proud of this book in some respects than the other ones because it took a more challenging pile of information, tried to synthesize it, and I tried to explain stuff in English, which has a price. Some people think this book was still too dense. I mean, there is no synonym for constitutional. I get it. It's a long word. But there are others who, toil in these fields who thought that I simplified stuff too much or I personalized. When I wrote about the justices, personally, they would say, what's that doing there? Why is that there when you're discussing constitutional law? Because it's fun, it's interesting, and they're just people. I mean, there's a great story, maybe I'll leave you with, apropos of nothing. I can't tell you which justices I talked to, but an intermediary told me, another justice who I saw when the book came out, they said, the Chief Justice wants you to know he doesn't have a bald spot. Because I'd written in the book that, he's really sensitive about his bald spot. So if he can control a photograph, when he's photographed with the other justices or when, the class photo with all the law clerks in any given year, he'll want to hide his bald spot. So I was told by enough people that I believed it. And so when I heard this from another justice with a smile, the chief wants you to know he doesn't have a bald spot. I says, of course he does. So my question is, why is he saying that? And why is he telling you? And this justice said to me, you'll have to figure those out yourself. I'm just the messenger. And there was a private dinner at the Supreme Court in honor of a lower court judge. I somehow got invited to it by the person who was hosting the party, and other people were around and they heard this. So I'm not divulging anything I promised to keep secret. I went up to the Chief Justice, said, hello, David, nice to see you. Nice to see you. I says, I got to ask you something. You do have a bald spot. This was sometime after I had been told this. He says, what do you mean? I says, no, I was given a message that you were telling me when the book came out that you told me you don't have a bald spot. And you do have a bald spot. So do I. Look at it. And he laughed and he said, I was just kidding. And I said, so listen, I was pleased you read the damn book or at least looked at the index. And he laughed. So if I had to choose between that explanation and he really doesn't think he had a bald spot, I'm pretty sure he knows he has a bald spot, just as I think he knows, and I know, that Obama's inauguration crowd was larger than Trump's. But I mean, it's always nice to see that people have read your book. By the way, at that same gathering, another justice who I won't name went up to me and said, nice to see you, David. What are you doing here? And I said, that's kind of hurtful, with a smile. And they said, what are you doing here? And I says, well, I was invited. This was mostly majority. I think 7 or 8 of the justices were there. There were other federal judges and there were friends of the honoree, et cetera. And I said, I was invited, too bad for you. And the justice says, will you be writing about it? And all I could think of was, only my conversation about the bald spot. So anyway, I'm going to now wonder for the rest of the day about what other books I should have recommended, but I did okay in my list.
Yep, totally fine. I appreciate you taking the time to speak with me.
My
Uh,
pleasure. This is an ambitious podcast, and as we said when we began the conversation last year, um, uh, okay, well, earlier today, um, uh, this is a far better use of your time than studying contracts and torts and federal practice. So
I'll try to do both.
when you've decided to apply to law school, call me up and for a small fee, and we can go over the details again.
Yeah, for sure. Thank you so much.
My pleasure. Take
Okay,
care.
you too.